Hello friends, in the series on the income tax cases, today we will discuss a very important issue on section 143 subsection 2 notice. The issue is that even if the assessee does not file his income tax return on time, that is the time allotted by the notice under section 148, which was in the old regime was 30 days. So if the assessee has not filed his return of income within the time of that 30 days, then can the assessee take the plea that after filing my return of income, section 143 subsection 2 notice has not been issued and my whole assessment is null and void. This issue has been taken by the Honorable Delhi High Court in the case of Principal Commissioner of Income Tax versus DART Infrabuild Private Limited, which has been duly reported in 460 ITR at page number 532, and the date of the judgment is 17th November 2023. In this case, one more issue was there regarding the service of the notice at the old address. The case relates to the assessment year 10-11. The notice under section 148 was issued to the assessee at the old address. The assessee has already intimated the assessing officer about the new address. It was clear from the file of the learned assessing officer that there is MCA record available on the file of the assessing officer which talks about the new address of the assessee. The assessee has filed its subsequent year return at the old address, but the intimation of that subsequent assessment year was issued to the new address, meaning thereby that the assessing officer was well aware about the new address of the assessee. In spite of that, section 148 notice was issued to the old address of the assessee. The assessee plea was that the assessee came to notice of section 148 notice only after section 142 subsection 1 notice has been issued to the assessee. The department was taking the plea of section 292BB that says about notice deemed to be valid in certain circumstances, but section 292BB comes to the rescue of the department only in cases if the department has not objected or has raised the ground of not receiving the notice during the assessment proceedings. And it was also clear from the facts of the case that the assessee has objected the non-receipt of the notice on time during the assessment proceedings. So friends, I always say that whenever we receive the notices or at the time of during the assessment proceedings, we should take our maximum grounds or raise our maximum objections so that the department cannot play on our ignorance. When this matter came to the tribunal said that in the present case the assessee got section 148 notice only after issuing of the notice under section 142 subsection 1, meaning thereby that the assessee didn't receive the notice under section 148 on time in spite of assessee intimating the new address to the department. So on this ground, the case goes in favor of the assessee. And the next issue of non-issuance of the notice under section 143 subsection 2, before completing the assessment, the department was taking the plea that since the assessee has not filed the return of income within the period of that 30 days, so the assessee cannot take the plea of section 143 subsection 2 notice. But the court said that in the present case there is no denying the fact. The evidence is on the record that the assessee has filed the income tax return under section 148. So before completing the assessment proceedings, it was the duty of the revenue to issue notice under section 143 subsection 2. Friends, this case is very important because it may happen that sometimes we are weak on the merits, but if we can take successfully the legal grounds, so the case may go in our favor. These grounds are very important. We should try to raise the maximum objections at the time of the assessment proceedings. Nowadays the situation is like that. The whole success of the litigation depends on how the assessment proceedings have been taken care by the assessee. So the good advice at the level of the assessment proceedings is very essential. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus DART Infrabuild Private Limited, and this case has been reported in 460 ITR at page number 532. The matter has been decided by Honorable Delhi High Court and the date of the judgment is 17th November 2023. Thank you, friends.